from a different perspective than you often have heard here at the Best Practices Conference. We've got a group of litigators to talk about terms of use and privacy policies and what litigators have learned in terms of what the best practices should be for those people who actually draft terms of use and privacy policies. So I think it's going to be a very valuable session. We do want it to be interactive, so please jump in with questions. And we have an all-star cast, and I'll ask each of you to spend about 30 to 60 seconds just saying a word or two about yourself and your company, just so the audience has an understanding of your perspective. Renee?
There we go. Renee Lawson. I'm Deputy General Counsel at Zynga, a little game company up in San Francisco. We actually have done our share of litigating privacy policies. We, alongside Facebook, had a case brought in 2010. We won on a motion to dismiss in the U.S. District Court, Northern District, and the Ninth Circuit just a couple of months ago affirmed that dismissal. So interesting topic for us.
Great. Hi, I'm Blake Lott. I head up litigation, employment, and regulatory disputes at LinkedIn, and also have had our share of tussles litigating user agreements and privacy policies, as well as dealing and negotiating with regulators around the world about what's in them.
Hi, I'm Wendy Mantell. I am Privacy and IP Counsel at Hulu, which is very recent for me. And in my prior 10 years spent them with Ian litigating at Greenberg Traurig.
Hi, I'm Hillary Ware. I'm the Associate General Counsel at Netflix in charge of litigation and regulatory, where I manage the litigation, regulatory, privacy, and labor and employment. One of the special joys of being at Netflix and at Hulu is we have the Video Protection Privacy Act, which is an old and irritating and terrifying statute that we cope with. So we actually spend a fair amount of time thinking very carefully about our privacy policies given sort of the legal landscape we face.
I'm Bart Volkmer. I'm at Dropbox. I'm an attorney there. I work on litigation and regulatory matters. Before Dropbox, I was at Wilson Sonsini for a number of years. Hillary was my client on a lot of Google matters. So I did a lot of litigating for Google and other tech companies in the Valley.
Terrific. I've included in the material some excerpts from my treatise on online contract formation as well as arbitration provisions and enforceability. And I want to just spend a quick minute outlining an overview of the law before we talk about best practices. I think we all know that the gold standard, in theory, if you can do it, is to, when you present terms of use, to present them in a way where a user is forced to check a box, scroll down, press a button responding to a specific question, and doing so many things that it's very hard for a judge to say there's no assent. The reality is many products just don't allow that to happen. It's just not possible. And we all remember in first-year contracts class that it's actually not required to get express assent to form a contract. We learned in first-year law school that a contract can be formed expressly, offer acceptance with consideration, or impliedly. And you can have an implied contract when you have terms and someone acts subject to those terms. And I've argued since the first edition of my treatise that when you're dealing with the internet, that most users know that any website is going to be subject to terms of use, and that should provide notice. And if someone goes on a website and uses the website, that they should have inquiry notice and that they would be bound. Now, courts have generally not followed me on that viewpoint. And indeed, 14 years after I first made that argument, it is still true in litigation that if you have express assent, if you have the gold standard, it is much easier to present your case to a court. It's easier to get summary judgment if you're relying on a contract. It's easier to prevail in a motion to dismiss if you're relying on a contract. And that while many courts will enforce contracts based on implied assent, notice, and changed conduct, there are a few courts around the country that have not. Probably the most prominent cases that you're aware of, the In re Zappos case from Nevada, where a link at the bottom of every single web page alerted users that there were terms. Now, there were other factors that came into play, but that was one consideration that the court said that wasn't enough. And the Cvent case in the Eastern District of Virginia, where a court said that a plaintiff could not even state a claim for breach of contract if it was based on a posted terms where there was no express assent. Now that is dead wrong. That contradicts everything we learned in first-year law school. But if you're in that situation in litigation, you have the proud privilege of being able to go to the Fourth Circuit to get it corrected or do something else. And that's part of the problem as we drill down. So to start off the discussion, I wanted to turn to Wendy and ask you, one of the issues that you deal with when you're trying to prove that you've got a contract is proof that the user in fact assented. And Wendy, how does that come up in litigation, and what does that suggest for best practices?
Sure. So many times we're focused on how we can get express assent, but not necessarily how we can prove that we've gotten express assent. Some of the ways you can do this is either from a product perspective, make sure you are recording in some way, even if it's just a database that puts the date the person agreed to your registration agreement, which may be just the date they registered. Or another way that it comes up in litigation is through affidavits. You have somebody declaring that the only way for a user to pass the registration screen is by clicking the assent button. And generally, you may be going to have a user denying that they did that. But if you're technically set up so that you can't pass the registration screen until the assent button is clicked, that'll generally get you most of the way there. It's also important for you to record the specific dates in which your terms of use go into effect. So many of us have different versions of our terms of use that have been in effect from time to time. And it's important to keep a good record of the track record of your dates that each specific version of your terms of use went into effect, so you know exactly which version you're dealing with in litigation.
I think you can also, the other question too is in class actions, what version you've assented to also gets very, very tricky, because we have sort of immaterial changes like the has become a, right? Which may or may not be immaterial, but in general, this little stuff, we clean it up, right? We may do stuff, and technically speaking, you're a different version than the person who hasn't accepted the grammatically now better worded, but not substantively different policy. So I do think it's also, especially when you get into litigation and you're defining your class, right? Obviously, you can defeat an overly broad class with the argument that different users are sort of different terms of use in a way that's meaningful for the case that's being litigated. But from my perspective, it also becomes very complicated when you're trying to go in on the back end and figure out of millions and millions of users which people expressly accepted the current clause, which means they're definitely in the class, which people are within the year of not automatically renewing but are probably in the class, but we haven't quite figured that out, which people have not accepted but haven't been termed out yet. And it can get very headache-inducing in the context of trying to figure out how you define your class. There's no way around it, but it's definitely not my favorite day.
It brings up another point, which is when you're making modifications and how to get express agreement to modifications, and whether you really need to get express agreement to modifications, or you can do more of a notice and accept, and you're working from an implied basis then. But a lot of companies end up sending out an email, putting in their terms of use that in order to modify the terms, they may send you an email. Very important to keep your email current so that you can get the email and receive notice of a change to the terms of use.
I think one of the things that I take away as a best practice in looking at litigating terms of service and privacy policies, when you're on the end of receiving either a regulatory inquiry or litigation, you need to know your flow. And the sooner you know your flow and the sooner you know your data, where the data is, and not just for preservation purposes, for evidentiary purposes, the better you are able to formulate your legal strategy. So if you're not in there knowing where, when do the terms go out, what do they say, how can I prove it, you're going to be very ill-situated for purposes of putting together a defense. And we actually had an instance a few years ago. We had a consumer class action that had been pending for a while. AT&T Concepcion came down. We'd been litigating for quite a while, and lo and behold, we said, well, we have an arbitration clause. We'd like to go in and seek enforcement of that 2.5 years into the litigation. And fortunately, we were well positioned to go in with the flow, with an affidavit that said this user assented on this date through a Facebook flow to our terms of service that included an arbitration clause on that date. So make sure you understand your product before you formulate your strategy.
We have a question?
Yeah, I had a question about the modification.
The question for those who didn't hear and for the video was what's your view about just saying check back here frequently as opposed to email notice with respect to modifications, because a lot of startups in particular don't like to provide email notice.
Ian would tell you check back frequently is not the way to do it.
Well, there are courts that have held that if one side retains the unilateral right to change the contract is illusory. And so I think that's probably not a best practice to do that, although it's a very common practice. But it also depends which state's law applies. In California, I think there is some risk that the whole contract could be ruled illusory. But to Wendy's point earlier, I think if you say we will do X and then you do X with respect to amendment, whatever that is, then you have more of an argument. You also have more of an argument if you say you'll provide advance notice for some period of time before it takes effect. I mean, it's almost a sliding scale.
One of the other things you can do is just post a prominent notice on the home page. So, somewhere, doesn't have to be, bold and flashing, but somewhere where it's conspicuous so that users can see, we've made a material change to our terms of use. This change will go into effect in the next 30 days. And you give users time to see the notice and then time to decide whether they want to continue using the service. You can make that argument that that's enforceable.
I wouldn't want to be in the position of defending they should have checked the website as a basis to hold a user bound by a material change in a term of use. I mean, yeah. I'd take a run at it. I've got great outside counsel in the room who would be happy to do it, but Joe Gratz. But I think it would be very hard to do it. You could maybe get a better argument if you had it on an account page and you were able to prove that the user had logged into their account or in the context of updating payment information. In other words, you probably have to bootstrap some sort of, we have evidence this person saw this or had reason to see it or ought to have seen it. Some combination of website, general notification plus account page information. Depends how material it is, but it would be hard to do, I think.
Yeah, go ahead.
I would think that providing notice of material terms is definitely a best practice, be it email or Butterbar or however you want to do it. And not so much because we can have arguments about Zappos, and we can have arguments about the cases and the jurisdictions in Europe and United States and California. We can go into very deep legal analysis, but really, if you just want to do right by your users, because if you're ever in a litigation and you're saying to the judge, like, hey, you should enforce this term, and this is a theme I'm going to keep coming back to you today in other parts of the presentation, is just doing right by the users, having something that you can look to and say, Judge, we did this right. We are the good guys here. The atmospherics are in our favor, I think is always important in litigating close calls.
Mm-hmm.
But I think that's also meaningful on use of email. As a small app developer, you may or may not have email. That email that was provided may or may not be good email, either in the first instance or anymore. And so if you're looking down the road of trying to defend your actions, you also need to make sure that if that's what you're relying on as your means of communication, making sure it is an effective means of communication so that you can stand up and say, I'm doing right by my users. There are lots of different ways to communicate with the user via pop-up or other ways users may prefer to an email, and you just need to know your user base.
I mean, it does in the analysis in terms of how one-sided it is, but if it's a unilateral agreement, then the analysis shouldn't be all that different versus if you actually had a negotiation.
So, Renee, let me turn to you about a related question. We used to have nice big screens where we could present things in a very big way to users. I still have a big screen. But the reality is most people in the United States access information on small screens. As we move to mobile, how does this change the analysis for best practices in litigation?
So the last whole session was on best practices in terms of service and privacy policies on mobile. It was the whole theme of it, so I don't want to reiterate that. But there are certain challenges as we move to mobile, or as we've moved to mobile, real estate being a huge part of it. And then friction points. And the friction points can come in a couple of different ways. Users first and foremost, not wanting to have a bad user experience. But the second part is developers. So we all have clients who are developing for a little screen, and it is not easy to fill your funnel in the mobile environment. And so having to balance those two things can be challenging. The last panel, one of the panelists talked about not wanting to surprise your users. We talk at Zynga about surprising and delighting our users, and so I always, in my context of with my legal hat on, we don't want to surprise and disturb our users. So again, be the user. Go into your production environment, go into the live environment multiple times. Experience if you had an issue, what that issue be as a user. One of the things that I really think about a lot is our developers frequently make opting in really, really easy. How easy is opting out? Opting out should be if you go in front of a regulator or in front of the Better Business Bureau or in front of a judge or in front of your grandmother, you should be able to showcase my user experience is super easy. The opt-out is as easy, if not easier, than the opt-in. So make sure, once again, this is my theme of knowing your product, knowing your flow. On the friction points, that's a really tough conversation to have with your developers. And so you have to put your legal hat on, but on the other side is your business hat, of coming up with ways, one, to advocate on behalf of the law and try to persuade. You may have to raise your right hand and you have to be proud of what you did here in your development process. But the second part is to really think about how can you be creative within the context. We talk a lot about presentation. So what do your little buttons look like? How can you make your aesthetics of your button satisfy the law, be able to showcase that we were compliant, but also a good user experience that was what you were intending. So using things like colors, graying buttons out, making your language embedded in the button. So instead of just using consent or accept, can you use 4 words that actually get across what they are consenting to rather than burying it in a link. But work with your developers on being creative, on being compliant, and the more you partner, I think the better off you are. One word of the wise, this is such an unstable area, and products are so unstable, and I think one of the things you have to think about is how can you evolve with your product and the law. So one way is to know, maybe we might have to put a notice in at some point. We might need to pop a push notification. We might need to get an assent at some point if we change things. Make sure that your app, in this case, can do that. Have your developers build an app that you can communicate with your users if you need to down the road. But always being very much in sync with the legal requirements and your app and how it works.
So something kind of basic to add, but
and actually, before you do that,
Oh,
there was a big
okay.
LinkedIn case on Thursday that I probably isn't going to talk about. But there was one thing that Judge Coe said that I thought was really great.
Okay. No, go on, please.
Which was complimentary. I should get her language because I wrote it down. I thought it was good, and I thought it was, there were some things that were done really well that she pointed out. And one of the things she pointed out there, this was a email harvesting case. I don't know if I'm stealing your thunder.
It is not an email harvesting case. They
That's
said
what
it was an
call
email
it.
harvesting case, but all of those claims were dismissed. The motion dismissed stage as totally groundless.
So some great results. An interesting case. I suggest that everybody read it. But Judge Coe did give some kudos to the way that that LinkedIn had presented this was actually a just-in-time notice. So it was actually a POP. It wasn't buried, and she commented that it wasn't buried in the terms of service or the privacy policy that you had to go down 3 layers to get. That she commented this was actually presented very well to the users and had an express opt-out next to it. So if you want to see something that presented well to the court, I would suggest you take a look at the decision. So, sorry.
Yeah, no, that's fine. Thunder, I've got plenty more thunder, so that's fine. So it's actually quite similar to what I was going to talk about. So one thing, very basic, is learn more is your friend when you're advising your product people. You want, because when you're talking about difficulty of providing the information right there to your product people, because they're going to be like, wait a second, I'm testing this. This language gives me, 8% drop in conversion or whatever it is, and you're negotiating back and forth about whatever the language is going to be, both with the common goal here of trying to be clear and provide the right notice and consent at the right time. So, it's a very difficult task to be able to do it in the very limited real estate that you have. But you're gonna have an easier time talking to your product people if you come to wherever you have and they say, hey, let's have a learn more button for those people who want to know more. It's right there. You can provide more information. So that's one thing. Just in time. Do what you can in that small space, and then have a learn more button, because when you're having that negotiation with your product person, they're going to be much more willing to provide a lot more language and disclosure in the learn more, because it's not going to break up the flow. Separately, I do think that the point about Judge Koh, and there were some good things about the opinion, some bad things about that opinion. But one thing that I think that is an important lesson is that your job's not done when you finish writing your user agreement and privacy policy. It's just not. The fact of the matter is, and particularly Judge Koh, and if you look at the Gmail decision and judges across the board, they are going to look at whatever you have in your user agreement and privacy policy with a lot, they're going to be a lot more skeptical in whatever it is that you provided the right disclosure to get the right consent. Which makes sense, right? I mean, if you're doing it at time, you're providing the information at the time that somebody's making the decision, you're going to get more leeway because it's in context. Otherwise, I think that you've seen this trend already in some decisions, you're going to see it more, where you're going to have a greater degree of skepticism to get the whatever consent that you needed in your user agreement and privacy policy, because it's further away. You can still do it, but the court's going to look at it with more scrutiny to make sure that you're right on point. So what you need to be doing is not just writing. Your job's not done when you've drafted the user agreement and privacy policy. You need to be doing it yourself if you're at the startup and you're the only person there, or you need to be working with people on your product or privacy teams, et cetera, to make sure that you have those just-in-time notifications. Because going to Bart's point earlier, the goal here is really to all of us, every company here, and probably every company in this room, what we're here to do is, in a lot of ways, make our members' lives better, and we've done that in a lot of ways. But the way that we're going to stick around in the long haul is we're going to do that by making sure they understand whatever it is they're doing, and the way to do it is not just in a terms of service. It also has to be in the flow.
I would also go ahead.
Yeah. Repudiation of, I don't repudiate any of my customers. No, I'm sorry.
When the customer says, I did not opt in, but they did, how do you preserve their opt-in?
Well, all of the companies at this table luckily have a lot of data, and if they said that they didn't opt in, then there's probably something somewhere in the database that could prove whether or not they did. So but it may depend. So the short answer is, if anybody wants to opt out, they can opt out of individual services to the extent that we allow that, or they can always cancel their service, right? They don't have to go ahead and use the service. If you're talking about a litigation where they're saying, okay, I didn't agree to this, then like Renee said, in her case, they went and they looked, and in fact, I didn't get all the context, but it sounds like the guy that was the named plaintiff had agreed to the arbitration clause, and they were able to use that and say, oh, actually you did. I've got the data, and I got an affidavit that says that you did agree, and then you can utilize that. So I think that it may depend on who you are and what you're at, but for bigger companies, this is something that I'm not sure whose point it was, but your company probably has the information about who agreed to this, and you want to go ahead and look at it if somebody's saying that they didn't and they're using it to try and create some sort of classic action against your company.
I would say in general it's a good idea to know when you have assent to contractual terms across the board, whether it's electronic or actual paper copies. The other point I was going to make is most people here are probably venued in Northern District of California by definition of having your companies here. And obviously the sophistication of judges varies a great deal. I have taught some judges how to turn their computers on for the first time in their adult lives. which since they were above 80 seemed like it was overdue. But I've also had judges who openly argued with me about how the flow worked based on their having been a sophisticated consumer, which is great, but it's a little nerve-wracking. They're like, well, no, I'm on Facebook. That's not how it works at all. See, when I went on last night, and on the one hand, you're kind of saying, well, actually, this is bounded by what's admissible evidence, not your personal life experience with your, social app. That's not, by the way, the argument you want to run with the judge at all. But I do think it's important to know when you are litigating these kinds of clauses and you are in a relatively sophisticated jurisdiction, there's going to be a fairly high bar. You can't just sort of throw an affidavit in that says, here's the flaw, here's what we do, because if the judge or the court realizes, or they have clerks, which everybody does, that's not actually what you do, or it's incomplete, or it's not benchmarked against acceptable practices for other similar situated companies, I don't care if it looks good in the affidavit, you're going to get hammered in the real world because, to Bart's point, it just doesn't feel very good, and people are more sophisticated consumers. So I think it's also really important to be aware that, especially in areas where the judges are very savvy, the bar is not just establishing that you've done the 4 correct things, but that it feels like it has integrity from a user perspective.
One point I wanted to mention to your question is very important to make sure that you have a process that is going to meet evidentiary standards, so that in your company, you're retaining things in the ordinary course of business. Because if you have files but they've been haphazardly collected over the years, then you may actually have a problem getting the issue admitted. And it does come up surprisingly frequently in litigation, where people who've clicked the button say, gosh, I just have no recollection of it. They have fuzzy memories once they file suits. So we wanted the panelists to talk about some specific drafting issues. Once you sit down, you're trying to draft it. And Bart, could you talk a little bit about the importance of the type of language you use?
Sure, yeah, I'd be happy to. So I want to talk a little bit about just kind of using plain language in your terms of service and your privacy policy with your end users. At Dropbox, our service is really easy to use. Now it's one of the main value propositions of Dropbox. There's other file storage and sync services in the world when Dropbox was created, but Dropbox was able to make a system that was very easy and intuitive to use. And if you went to the website and you learned about how does this product work, it's always very simple language, very straightforward, and easy to understand. As lawyers, we all know that sometimes the legalese in an end user terms of service is not so easy to understand. It's not very delightful to get through. And so we wanted to have a little bit of a syncing up of what Dropbox does on the product side with what it's doing on the legal side. And so we wanted our terms of service to be very straightforward, very plain language, and easy to understand by regular humans and not just lawyers. And so we went about this project a few years ago. And I just want to give an example of this, because when you talk about using plain language as opposed to legalese and end user agreements, I think people get nervous, especially litigators get especially nervous, extraordinarily nervous, that if we don't if we don't account for every single edge case, if we don't have the exact language needed to button up our liability, we're going to be exposing the company to tons of risk, and then that would be a horrible day for the legal department at the company. So I wanted to address one particular area where this came up for us, which was in the license grant we get from our users. They are uploading their stuff to Dropbox, and we need to get a license to be able to do things with their material. And you could, on one hand, you could say, okay, user, you give me a worldwide, non-exclusive, royalty-free, perpetual, fully paid, revocable license, and you could use all the legalese. You could look at 13 different adjectives you could use to describe the license grant, or you could do what we did, which was kind of just say, your stuff is yours. You give us permissions to do the stuff we need to do to run the service. Those permissions include X, Y, and Z in very plain language terms of why we need to get this license grant from the user. That's what we ended up doing. And I have had conversations with people like, well, you're not getting this explicit license to cover every single copyright use. You're not getting an explicit license to cover every single use in the world. Aren't you concerned that you could be exposing the company to liability? And I think ultimately the answer to that is no. I mean, we'll find out if we ever have to litigate it, and hopefully we don't. But if we do have to litigate it, I think a judge and a juror would be very sympathetic to the approach we've taken. When you read our license grant, you get it, you understand. And if we're falling within the spirit of what we say in that terms of service, I think that we're going to get a lot of sympathy. And I don't think somebody who's trying to, on a technicality, say, okay, yeah, I knew this, and I read the terms, and you presented them correctly, and I could actually understand the language, but you didn't have I didn't grant you the rights to do X, Y, or Z on some edge case. I don't think a judge is going to look very sympathetically on that. So I think ultimately, if you present the terms in a very plain language way that people can understand, you might be opening yourself up to some hypothetical risk, but on the other side of it, you're gaining a lot of credibility with fact finders, with judges, and I think ultimately it's more of a risk to have that super hyper technical terms of service that you can't understand. I mean, I just got a new iPhone, a month ago. I mean, God bless Apple. I mean, those are very, very buttoned down terms, but they are pretty hard to get through. And so I think that ultimately you're probably exposing yourself to more risk by having the hyper technical language. So that's just a little bit on kind of clarity in the language, and I think that's definitely the trend.
Question over there.
What do each of you think about? I've seen this done by some companies where they do have that really long language, and then they do kind of give you the sidebar of this means you have permission to do X, Y, Z.
I mean, I think that's great for site terms of use. For mobile, that's a little harder to implement.
Legal estate doesn't allow that anymore.
Yeah.
I think it's a good idea. We do it. Yeah, and I think it straddles. I think that Bart, like, we all want to be able to talk in plain English, right? And it's super important for everything we're talking about to be able to communicate clearly. And I do think that Bart is correct that overall, a judge is down the line is going to be more going to cut you more slack if you've communicated clearly. Always. The issue that we occasionally have is that you are, like, actually regulators are of two minds of this. I have found is that sometimes they say, okay, strip everything down, be simple, and then you'll do something like, where is it in your privacy policy? Add it to your privacy policy. So you're going both ways, and that's how we've ended up sort of compromising, where we have on the left rail we have a sort of very simple sort of, here's what we're doing, and then on the right rail sort of more detail. I don't know. I don't know for sure whether or not there's really a push and drive to simplicity, and conceptually I really agree with that. But sometimes more disclosure, more disclosure is there to provide people more information. So it's not an easy thing. That's how we ended up. That's how we've tried to split the baby, so to speak, and. Actually, I don't think it's a split baby, but anyway, that's how we tried to deal with the situation, and I think but it's a challenge all across the board.
You should think about your environment too. And we're a game company, so when we rolled out a new privacy policy, this is a few years back now, we created Privacyville, because our games end in Ville. So it was actually the gamification of our privacy policy, and rewarded users to engage with it. And they got virtual goods to play in their games by engaging with our privacy policy. So we had all of the legal elements within the actual policy, and then a really user-friendly approach to explaining it. FTC really liked it, but I agree with Blake. You never know who you're going to get on the regulator side of. Yes, I want it simple. No, I want it completely buttoned up. And then when you get to litigation, it's a totally different environment. So,
the one thing I would add, and I completely understand where Blake's coming from, and I think that's also a good approach. I think the one thing is if you need to continue to disclose more things, and there is for regulatory reasons or for other reasons, some new case comes out, you're like, oh gosh, we really need to change our terms of service or our privacy policy to account for this. I think there's a difference between maybe having to add stuff because you feel like you're forced to, and using legal jargon. I think throughout you can avoid the legal jargon, even if it has to the privacy policy and the terms have to get bigger and bigger and bigger. You can avoid the jargon and try to have the language itself be comprehensible to regular people.
Well, Renee, another drafting issue is in trying to make things very consumer friendly. Is there any downside in having lots of positive provisions in the terms of use?
So one of the things that I think everybody puts into their terms of use and becomes one of the very first things after we've had the repudiation from the user, which happens almost every single time you have a consumer. I didn't agree to that. We often have a form selection or ADR provision, and I'm going to leave ADR aside. But the form selection, I think, is an interesting piece because we who've been in smaller companies trying to deal with consumer actions in a nationwide context, more so pre-AT&T Concepcion, more swinging toward arbitration, but came up with some pretty creative alternative dispute resolution. So things like, if it's forum selection is San Francisco, because that's where I am, that's where I want to hang out, and I don't really feel like going to Omaha this week. But if you're in Omaha and you make a claim for under, say, $10,000, you can opt not to come to San Francisco, and we'll just do it on the papers. It was a very creative use. Even within the context of selecting an ADR, to make it more consumer friendly, folks have tried to localize it. You know, if you're in the Midwest, we'll go to AAA in St. Louis, for example. If you're in the South, we'll go to Atlanta. Really trying to make it user friendly. But some of us still have just, you'll come to San Francisco. So one of the things that is really interesting when you go to litigate that, whatever it is, and we've done this in Nebraska and various different places, is you go to a small town judge who has a local person who says they've been wronged by your ugly app out of Silicon Valley, and they want to be righted in their local court, and to try and go and enforce your forum selection in, we'll give you the benefit of the doubt and say it's Omaha. Might be someplace totally small. That's a really interesting problem to have. And so one of the things I would suggest is don't give up. There is a good network of folks in-house. I know when we had the first one, we reached out to folks at eBay because we knew that they had done this. And to find a local lawyer who has good standing in front of that local judge, who can get in front of the local judge and be the advocate of why we have assent to this very clear clause that's written in plain English or in legalese or both. But it's, remember who your audience is when you're writing the clause and how you're going to get it to stand up in court.
I didn't want to become the champion of legalese. I'm not sure.
No,
It's like simple or legalese or both.
But no baby
I
splits.
guess maybe I'm both. I prefer to be. I think that Bart's point was right, which is longer can still be simple.
Absolutely.
How do you vet in your companies when you make changes, whether something is solving one problem but then possibly creating another?
Kind of full employment.
Yeah.
I mean, I think that we go through multiple iterations, and whenever you're in-house, everything is sort of cross-functional, right? I mean, any one little decision ends up having reverberations. You know, I've changed one word, and probably people have been like, "No, we just flew over to the next screen," and then you have to change your word back or find tinier words, tinier plain English words. But you know, I do think that the harder challenge is when you're trying to update your terms of use in a way that you think is better, but that either then causes you to think, well, do I need a separate privacy policy or do I need a separate social policy? Can this flow into one uniform policy? What if we're becoming, expanding internationally? Should we have one term of use everywhere? Should we split it out? What are the pros? What are the cons? And those are discussions that are largely legal in nature in the sense that how you structure that to comply with the relevant laws is important, but goes very quickly to product, goes very quickly to sort of, a lot of larger regulatory issues, a lot of issues how they want to present stuff, a lot of issues of where you're going to be, to your point, physically venued or not. And so, I think those, at least at Netflix, and it being a lot of people sort of having thoughts and at the table at various moments in time. I'm sure the same is true for you guys.
Yeah, absolutely. My particular position is very cross-functional. I'm always meeting with various stakeholders across the company, particularly not just with our terms of use and privacy policy, but with any user-facing messaging that we have.
What are your thoughts about multiple documents versus one document? I mean, Hillary, you raised the issue, and I think it's a good one because companies take different approaches for different reasons.
At a high level, I think it kind of goes to Bart's point, right? I would rather. I don't think you need to have one document. I don't think one document is necessarily better. You can pack a ton of crap into one document that then makes it inscrutable and complicated and difficult and has learn more buttons and, emoticons and all sorts of things. But I do think that, on the other hand, you're going to get yourself in trouble if you have so many sub-documents that the user actually can't figure out what the thing is that is governing what they're doing on your site right now. Or you can't.
Company can't.
Which is even more embarrassing when you're the lawyer. But, so, I think you want to be very clear, right? Do we have a terms of use and a privacy policy, and they work together? And that makes sense, and that's a fairly typical split. Do we have a different privacy policy in different regions of the world? Do we have them in every single country? Do we have one, and then, you have, those of you remember the Choose Your Own Adventure books when you were younger, if you climb up the tree, turn to page 47, if you go into the cave, turn to page 49. That's not how you want it to work, If you are in Belgium, ignore paragraphs 4, 7, and 11 is not a user-friendly term of use experience. So how do you structure it in a way that captures the relevant law, makes the user know what's governing his or her actions on the site? I think it's really hard to do.
Yeah, I mean, it's very complicated. I think particularly if you have, cross-platform product like Hulu available in living room, mobile, and PC, and deciding whether or not we have multiple user agreements really comes down to how different are the experiences, and do the disclosures really need to be different, or are the disclosures really the same? What are, how granular do we need to be in these policies, and what kind of information differences are there? And that's the kind of analysis we do when we're deciding whether or not to split off particular policies.
Blake, what about privacy policies? Are the drafting considerations the same for privacy policies as terms of use? Are they different?
I've never really thought about that. I think that what I would say is that the privacy policy ends up being a little bit more of a document that is actually less defensive, right? User agreement is often, I guess, sort of, I'm going to answer the question in a slightly different way, which is, I think it can be for both, but I think it tends to come up even more in your privacy policy. Like, all of these documents are not just defensive to protect you. They're also actually to, because the company, particularly in privacy, like, we're a company that believes in putting our members first, and part of putting our members first is really committing to privacy principles, right? And it's not just defensive about how if things go wrong, you're not going to be able to come after us. I mean, that's part of it, of course, because we're lawyers, and one of our jobs is to protect the company. But in the long term, one of the ways to protect the company is to commit the company to best privacy practices as well. And then we can, and I think that there may or may not be disagreement as far as like how explicit you should be about what your promises, what the company should promise as far as level of security, level of privacy, et cetera, that you'll do. But particularly in a privacy policy, I'm much more, and certainly from our executives as well, like executives, product people, they're saying that actually, hey, we need to be out there committing to privacy first and privacy standards, and not just like, doing CYA.
Right. I mean, I think it's also dependent on the kind of information you're collecting from your members versus, and what kinds of sensitive information you have access to from your members. So it's going to inform your privacy practices.
But I do think that the privacy, going through the exercise of doing a good privacy policy, which starts, whether you're Kamala Harris who tells you to do that, or just because it's good practice, to do your checklist of what am I collecting, what can I collect, that actually is a business practice. And knowing not just, okay, right now my app does X, and I know I need these types of information, but what else is out there that my app either does or can collect, and how does that fit into my business plan? And that's actually something that we as lawyers are forcing them to go through the thought process of how does the app work and what are its extensions is really business thinking and not just legal thinking. And so putting that value proposition on what is otherwise a really abysmal task is a good thing, especially when you're taking it to your business teams.
And also putting out there, what are vendors what are the vendors you're working with collecting, and how does that affect what kind of user-facing policy you need to have? Because for all of us, I believe we are the user-facing company, and our vendors may not be.
I think also it goes a little bit to risk management too, which is, you don't want to overly promise anything you're not absolutely certain you can lock down. So I love it when I see people say, we will never sell or trade your information, which I think is an awesome thing, and I'm delighted that you are the only company that's figured out how every third-party analytics company in the world works. But it's, anytime I see always or never, it just causes me as a lawyer to sort of have that brief moment of forgetting to breathe. I think you could say we believe in this, but the moment you say we will never trade your information, and somebody finds out that you are using this third-party analytics, which participates in a cookie pool through a different third-party analytics firm, so technically speaking, you have just traded your information, even though it's anonymized, hashed, and 3 vendors ago. You've just now stated something that's incorrect, and that's exposing the company to risk. It's important to have principles, and we don't want to do that. But I think you want to be very careful that people aren't. You need to know, and it kind of goes to Renee's point. You really need to know what your information is, where it is, what's being done with it, what you can say, and are pretty sure you can say, but want to be very careful about saying all over the place. And that doesn't mean that you don't want to have best practice. It just means that your job as a litigator is to say, okay, if we say we will always protect your privacy, by definition, the moment you have a breach, even if you're hacked and you took all best steps, you've just said you'll always do something that you didn't do. And that's a lawsuit right there. So you just want to be careful in how you overpromise in an effort to reassure the user. I think it's better to sort of be very clear. We take your privacy seriously. We do this. We don't do that. We don't permit this to happen in a way that's much more sort of keyed to the facts of the product and as you know them and understand them with the business's help.
So Hillary's point is, I think, super important. Leaving aside the regulators, because the regulators tend to be more on top of where technology is now and what expectations should be, the law has not caught up. And so the plaintiff's bar is very creative in trying to come up with causes of action to fit what's going on in our space. And the traditional hook has been the Electronic Communications Privacy Act, written in 1986. Really not for this context. And it is a square peg, round hole problem that both the plaintiff's bar and the judges have tried to grapple with. And in the privacy case that we just litigated to the Ninth Circuit, we got out because all that was up on appeal was the ECPA claims. And the judge said, the panel said, content's not disclosed. The facts of that were Facebook, back in the day, in the referrer header, would pass the Facebook user ID on to the app developers, who then might be passing it on to third-party advertisers. Those are pretty simple facts, no longer the case. We got sued as an app developer. We got out because the ECPA says not contents, no violation. That is basically address information. The referrer header and the Facebook UID might be PII, but doesn't fit within this statutory context. Zing, you're out. Facebook, on the other hand, is headed back down. And the difference there is, up on appeal, they had California state common law claims for breach of contract that remained based on the representations in their terms of service. And so they got out on the ECPA claim, but they're headed back down on what was said in the terms of service. And I think you're definitely going to see the plaintiff's bar gravitating more to common law because we don't have a statutory construct that fits what's going on. And frankly, by the time you litigate anything, our environment doesn't look like the statute anyway. So really, I think, important point that Hillary brought up.
Yeah, and I think that actually also highlights an interesting tension, which is that if you're writing for regulators, regulators have discretion whether to go forward, and they're looking whether something's reasonable. Class action lawyers are looking for a hook. And so if you have something that's reasonable and simple but maybe omits something, then there's a problem. Or if it says something under California law, maybe it's creating a promise. So there's a bit of a tension. You're obviously all at big companies. You have other people you can bounce ideas off of within your legal departments as well as outside counsel. Some of the people in the audience are at smaller companies. If you're at a startup, you're at a very limited budget. How do you try to balance these things besides, other than spending 100 hours and driving yourself crazy, trying to figure out what's the right balance between enough detail and something that's so detailed it might be unconscionable?
Easy one, Ian.
Yeah.
I like to throw the softball.
I think for the startup, for the in-house lawyers, the startup companies, or maybe the person who's working as an outside lawyer for them, but they're on a budget, is just sort of the trying to figure out what the scope of risk is and figure out where the most risk is. Look at all the cases, look at the cases that have been filed, look at the ECPA cases, decide where does the actual risk reside, and then not worry about the stuff way on the margins, because you can't know everything and every possible claim that could ever be brought against an online service, but you can know ACPA really well, and you can know some of the other class actions that have been filed against online services and app developers, and you can say, I'm going to guard against these 5 to 10 claims, these fact patterns, because a lot of the class actions are repetitive in nature. It's the same song and dance, just different company is listed as the defendant. And so I think you can keep up to date on what are the major cases, what are the legal theories, and then keep your eyes peeled for anything in the Wall Street Journal or New York Times about privacy or security, because a lot of times the lawsuits will flow from those things. So if I had 5 hours a week to think about this issue and that's it, that's probably what I'd do.
I think you can also look at other people's terms of use. I mean, you can pick companies, and I think the folks up here have pretty good terms of use. You pick companies that you think have the orientation that's similar to how you want to handle it, right? You think that they put consumers first. You think that they try to speak in plain English. You think that, and then, I will spend a lot of time just reading how other companies handle this specific clause. And if you get 7 of the same clauses from 7 different companies that you think, generally speaking, are trying to do it right, and read them, and they all roughly look about the same, the chances that all of those 7 companies have missed an extraordinarily important point of law is probably manageable.
And the chance that you're going to get picked off in litigation, not one of those 7, is probably
Exactly.
But you definitely want to think about how those terms apply to what you're doing in your company. Obviously, blindly taking somebody else's boilerplate provisions and putting them into your own terms is not a good practice.
Right.
And it's actually amazing how many business people will just say, let's do that. So,
Yeah, the problem is, or like if you're at a place that's resource constrained, and nobody is going to be like, great terms of service. You really knocked it out of the park with that, getting a promotion. But because it's like anything else, and you're going to be getting all like, where's the contract for that sales agreement? Where's all the things that are on top of everybody else's mind. So but the fact of the matter is that this is it. This is your terms of service, privacy policy. This is like the real protection. So if you're going to stack rank the things that you can spend some time on that is not going to have an immediate payoff, this is a place where you should spend a little time to make sure you have a decent one and make sure that people agree, because it's ultimately the firewall for anything that goes wrong. So it's not like the fact of the matter is you probably will put it lower on the list than a bunch of other things, but you can't have it so far on the list that you never really get to it.
I want to return to the notion of just-in-time information. That really originated in part with the Federal Trade Commission in the privacy area, saying that you should give disclosures at the time information is collected. It's now bleeding into case law in terms of use. From a best practices perspective, how do you determine if something should be, is a candidate for just-in-time, or if it's sufficient to be in the broader terms of use agreement?
I mean, some things you're just required to, right? Geolocation's a good example. I mean, Apple will just require you to do it anyway. It just forces it into the flow. If Apple's doing something in the flow, you can probably follow that as pretty good practice. And you can use that as an excuse with your developers. But there are just certain categories now that are rising to the top, bubbling to the top of being particularly sensitive, that may or may not be fully adjudicated, but you should be watchful of. And then I think it goes back to material changes. So material changes in your TOS, material changes in your privacy policy, where you do have an assent question. You're going to have a question about needing to do a pop-up or a notification, maybe not a just-in-time notification in that instance, but actually flow intrusion.
I think a real basic rule of thumb is, are you acquiring your members' data? If so, that's a good time to make sure that you're clear about what you're going to do with it. I mean, just in general, if you look at the general trend line of what the cases are about, where the risk is, and what people care about, and at the time of the acquisition, if you can, and because some of it will be not depending on what the service is. Some of it you may be able to do at the time, or it'll be ongoing, et cetera, et cetera. But that's if you're acquiring a bunch of your members' data, then look at what the disclosure is, and can you provide a clear, simple disclosure at that time? If so, do it.
And if you think it's counterintuitive, to what a user would think
That's a
is
great
happening.
point. That's a really, really good point.
Yeah, that's the flashlight, the FTC flashlight case is just the classic on that, right? So you think you have a flashlight that's free, that free app, and they're actually taking your location and beaming it out to advertisers.
Well, we have about 4 minutes that remain for questions. So I see the back of the room.
So I have a question from the perspective of a non-transactional attorney. I'd like the panel's thoughts, really anyone, on the subject of data privacy and security due diligence in the context of corporate acquisitions. Are you seeing companies, before they acquire other companies or take substantial positions in those other companies, doing the kind of due diligence that they routinely do, let's say, the environmental sector or accounts receivable due diligence? Are you seeing that? If so, why? If not, does that raise any questions?
Compound question.
Well, WhatsApp was that they did that over a weekend, right? That's what I hear. They had the discussion. So actually, a lot of it is like that's my understanding is that they had the conversation. It was like a couple days and then it's done. Like they couldn't have been doing any sort of great deep dive on the privacy practices in that. I think that so part of it is in the business reality. Sometimes you don't have very much time, and so it'll depend on that. If you do have the time, then I think it is definitely an area that certainly, our company, when we make acquisitions, if there is the time to do so, it's something beyond just sort of a general IP and or open source or things like that you look at. Absolutely, you should be looking at what the privacy and security practices are. But actually, some of that will be just from like whether or not we want to acquire a company in the first place. Will have to do with, do they have sufficient sort of temperament, outlook, et cetera, into how we would think about privacy and security. Because if there's not a good match on the culture on that, now maybe that they're just sort of very young and immature, not immature as people, but immature as a company, so they haven't built that infrastructure. But in general, those, we're looking for companies that also are going to place a high value on privacy and security of their members' data, so it comes out that way too.
I would imagine a good M&A lawyer will add that to the reps and warranties and build in an escrow. So ask your M&A lawyer before you get one.
Do you all have arbitration provisions in your terms of use and how effective?
Heads are shaking yes and no. So
Yes, we have an arbitration provision in our terms. We have not litigated them yet. I can tell you, just because we have a recent lawsuit that was filed that implicates it, that it's possible we'll be litigating them at some point soon. But Spotify just litigated theirs, and they were able to get the class action kicked to arbitration on the basis of a clause that was mutual, even with a carve-out. And certainly judges are open to doing that, particularly here in the Northern District.
And Blake, you were shaking your head in a different direction.
Yeah, we don't have one.
Do you think about it?
Yes. Yeah, it's that.
No. Never even crossed our mind.
Yeah. We can have a sidebar conversation on that.
I did include an excerpt up there on the materials on arbitration. That also includes a clause that we drafted that was upheld in a case in the Northern District of California. But the problem in this area is the law changes all the time. It really shouldn't, because it's the Federal Arbitration Act. But there are a lot of judges, particularly in California, as well as in Florida, New Jersey, and a few other states, who for years were used to striking these clauses. So they're trying to find new ways to do it. One suggestion I would say, and I know Zynga has done that in some other companies, try to map to the language of Rent-A-Center West. So the more that you can take away the threshold determination of enforceability and unconscionability from a judge who's hostile to arbitration and give that to an arbitrator, the better off you'll be with those clauses. There were several other hands, though, so I...
For the ones who have it, was that there originally, was it added? And if it was added, if you think about the express, how you would amend? Is it just the normal arbitration email?
How would you add an arbitration clause when you don't have one?
I would say that's, I mean, I was not there when Hulu added its arbitration clause, but I would say that it's certainly a material change.
Yeah.
You definitely need to get express assent.
Yeah.
So an email push notification is something where you're going to get that in the flow.
Other questions? We have 1 minute and 12 seconds, so a particularly succinct question. Okay, I see the questions have been withdrawn given the time limit. Well, the panelists will stay after for a moment or two if you have individual questions. This has not only been very informative, but with a group of litigators, one of the more entertaining discussions of terms of use and privacy policy. Thank you so much.